Thank you so much for inviting me here as a Daynard Fellow. I'm truly honored and very humbled. Thank you to Professor Daynard and to Carol Daynard. Thank you to Dean Spieler for your incredible leadership of this great institution. And thank you to the terrific faculty, especially Lucy, and to the committee, and especially Janice, and all of you who have shown me such kindness in this process. I can tell you it is great to be back at Northeastern. My speech is entitled Waging Campaigns for Change, a tribute to clients, community-based organizations, and labor. However, my working title includes a tribute to this law school for so many reasons. As a law student here, I was keenly aware of what a special place this is because I had transferred from a very conservative law school in Toronto. When I arrived at Northeastern as a transfer student, I was thrilled at the genuine camaraderie with faculty, the generous and sharing spirit of my classmates, and the welcoming environment I found for my then young daughter, Genevieve. In fact, my daughter, Genevieve, is also pleased about the renewed connection with Professor Daynard. A story that has become folklore in my family goes back to my student days when she accompanied me to an administrative law class taught by Professor Daynard. She was eating a chocolate bar that had gotten all over her face. I began wiping the chocolate off her face with spit, just as Professor Daynard asked about the Supreme Court's interpretation of a particular point. In a loud voice, my daughter, reacting to me, said, "Yuck." Without missing a beat, Professor Daynard turned to her and said, "You are absolutely correct." She went home that night to boast to all her friends how easy it was to go to law school. Northeastern has remained such an important part of my life and work. The co-op system that led me to legal services, the classmates who befriended me and whose friendship is so meaningful to this day, the countless fabulous co-op students who have contributed so significantly to every project that I have ever been involved with, Dean Spieler and the faculty who continue to inspire me, and the alums, many of whom I'm fortunate to have as GBLS colleagues. So I truly thank you in allowing me to return and be with you. In my talk today, I will address 4 of the many forces that burden clients who my colleagues and I, as part of the Employment Law Unit at GBLS, represent and how we attempt to respond to those forces. I will next talk about the involvement of our clients, community-based organizations, and labor in a current struggle to change the conditions faced by workers in temp jobs, along with 2 pieces of legislation that will be heard in a hearing tomorrow at the State House. Our clients who work in the low-wage workforce truly struggle on a daily basis to survive. They must fight to hold on to jobs, and more often than not, endure wage theft, exploitation, harassment, countless other indignities at work, and illegal denials of unemployment benefits when they leave work. So what are some of the forces that have contributed so mightily to their struggles? First, there has been a shredding of the so-called safety net. During Clinton's presidency, welfare as an entitlement program ended, and poor women with young children were forced into what's euphemistically called the secondary labor market, a place characterized by low wages, non-existent benefits, and workplace rules that provide no accommodation for any working parent, and especially a single head of household. Our response has been to prioritize poor parents in our work, which includes shoring up the unemployment insurance system as the safety net that has replaced welfare as a poor working mother's source of income between jobs. My initial work on systemic unemployment issues began with the terrific Boston grassroots organization, the Chinese Progressive Association. As a baby lawyer, I embarked with CPA on a 7-year legislative campaign to change the way in which unemployment benefits were calculated. We tried to achieve a sliding scale to determine UI levels, so that the smaller your income, the larger the percentage of your wages would be used to calculate your unemployment check. Needless to say, we did not succeed. But along the way, we defended the UI system against numerous attempts to be less generous to unemployed workers. We learned what it took in terms of the involvement of workers and the different strategies for inside legislative advocacy, and we learned how to influence the unemployment bureaucracy. With that knowledge, CPA achieved many later successes, including creating an Office of Multicultural Affairs within the Unemployment Agency, the first in the country, requiring the agency not only to translate their brochures in Chinese, but also subcontract with CPA to get critical information out to the community. CPA also partnered with labor to keep 15 unemployment offices open, rather than moving, like virtually every other state, to solely a telephone claim system. And in response to further tears in the welfare system fabric, at GBLS we have allied with labor to successfully keep monetary eligibility requirements low in unemployment, to increase the dependency allowance to the highest in the country, which is still a pathetic $25 per child a week. We have amended the unemployment statute to virtually guarantee unemployment insurance to all domestic violence survivors, ensured child care availability for unemployed workers seeking training, and kept benefits at the highest in the country and for the longest duration. We are working now to hold on to a small part of former Governor Dukakis's universal health care law, the medical security program for the unemployed. We have the only unemployment system in the country to provide health insurance to unemployed workers and their families. And recently, through litigation, we have assured unemployment access for workers who must seek part-time work due to child care. Through individual and systemic litigation, administrative and legislative advocacy, we have taken on the role of watchdog over the unemployment insurance system in Massachusetts. For this and for so many other reasons, we keenly feel the loss of Senator Kennedy, who was a champion for all workers, including the unemployed, and always supported our efforts. Additionally, through a partnership with our client ACORN and community and labor groups, we are waging a state legislative campaign to secure up to 7 paid sick days a year to care for oneself, spouse, parent, or child, and also to provide time for workers who are domestic violence survivors to care for their own or their family's needs. Over 40% of all workers, Massachusetts workers in the private sector, do not have a single paid sick day. And for our clients in low-wage jobs, that figure is over 80%. Although 3 cities have passed paid sick day ordinances, not a single state has yet to enact this law. It means that workers are forced to choose between the wages or even the job that they need and the family they love. Moreover, virtually all employed domestic violence survivors surveyed report problems at work stemming from the violence they endure. And a recent report unequivocally demonstrates that securing the right to paid sick days would have significant positive public health impacts by reducing the spread of seasonal and H1N1 flu, reducing expensive emergency room usage, protecting the public from diseases carried by sick workers in restaurants and nursing homes who currently do not get paid sick days, and reducing the spread of disease in child care centers and schools. Despite all these benefits, it is a hard-fought campaign, that we are waging not only here in Massachusetts, but with allies in many states. I wanted to take a moment as an aside just to talk about ACORN, our client in the Paid Sick Days campaign, as I'm sure you've read about them in the newspaper recently. I have to tell you that I am so proud to have been their lawyer on numerous other campaigns here in Massachusetts, which have included achieving an increase to the minimum wage, an increase to the earned income tax credit, and a Boston living wage ordinance. I truly believe that the viciousness of the tax against them is a testament to their ability to effectively mobilize poor people against established interests. So turning to a second significant force, it is the ongoing failure to enact meaningful immigration reform, which leaves undocumented workers vulnerable to abuse and fearing deportation if they exercise their workplace rights. In response, GBLS has prioritized legal services to immigrants, including those without documentation. In my employment unit, in addition to wage and hour and other employment representation, through the creativity of an alum, this work includes representation in tax controversies and community education on the benefits of tax filing, including ITINs, or individual tax identification numbers that allows workers to file taxes without Social Security numbers. Recently, my colleagues, including Brian Flynn, through class litigation, have forced the unemployment agency to respond to the reality of the growing number of workers for whom English is not their primary language, requiring multilingual notices. A class action suit on behalf of the primarily immigrant workers who drive cabs in Boston has also recently been filed by alum and adjunct professor Flynn to confront the total absence of the most basic due process rights. Importantly, too, my colleagues, such as Audrey Richardson, work closely with individual worker centers as well as work with and on behalf of an immigrant workers center collaborative that seeks to pool resources, knowledge, and organizing efforts so that they can better and more effectively address the challenges affecting immigrant workers. This has led to a collaborative and productive relationship with the Attorney General's office to vigorously pursue unpaid wage claims irrespective of immigration status, and to a role in shaping the state's underground economy task force to make sure that it's employers and not undocumented workers who are targeted. A dramatic example of this work was the representation of immigrant workers, primarily young Mayan parents, at the Michael Bianco factory in New Bedford. These workers were seized in a raid by ICE, or the Immigration Service, in March of 2007. Their only crime was working hard at a factory to produce vests for soldiers in Iraq. But these workers were rounded up at gunpoint, taken away from their children, including nursing babies, locked up in Fort Devens, and flown with their hands bound together out to Texas, only to be locked up again and put into deportation proceedings. Representation was provided by our phenomenal GBLS immigration lawyers who were contacted as the raid was happening by members of the Organización Maya Quiche, a community group in New Bedford that supports Mayans and Central Americans. In addition, my employment unit colleagues quickly learned that, like all good sweatshops that still thrive in Massachusetts and elsewhere, the Bianco factory had a day shift and a night shift, where the same workers did the same work, but were illegally deprived of hundreds of thousands of dollars of overtime through the use of a sham second corporation which employed them on the second shift. I am proud to say that the case settled with the workers reclaiming the money to which they were entitled. A third significant force or phenomenon affecting far too many workers result from the unprecedented levels of incarceration. This has led to growing unemployment as criminal records present a significant barrier to reemployment. Criminal Offender Record Information, or CORI, has become one of the most significant racial justice and human rights issues in communities of color. Nationally, 29% of the adult population have criminal arrest records, and 1 in every 100 adults is in jail or in prison. The racial disparity in these statistics is staggering. 1 in every 9 black men nationwide between the ages of 20 and 34 are behind bars. In response, we have launched a Reentry Project staffed by an alum who works on individual cases, assisting individuals seal criminal records, has partnered with the Union of Minority Neighborhoods and the Boston Workers Alliance to develop community capacity through training and increased legal resources, and is pursuing systemic administrative reform in the court system. And finally, fourth, in enumerating hostile forces, is the ongoing crusade waged by business to crush the labor movement. With the decline of unions, increases in worker productivity have been entirely delinked from increases in wages, all of which is accompanied by an obscene growing gap in wages, the evisceration of workplace rights, and vastly increasing inequality. Our response has been to work collaboratively with labor, to lend our legal expertise to campaigns that affect low-wage workers, but to do so not only as lawyers, but as dues-paying union members seeking to contribute to and strengthen the labor movement. So with this background of just 4 of the many forces stacking the deck against our clients, I turn to a series of tributes, which begins with clients. The contextual basis is the issues confronting clients who work in temporary and day labor jobs. All of the forces that I just described that come down on all workers hit the hardest on workers in temporary or day labor jobs. Tomorrow, a legislative hearing before the Labor Committee will include 2 of our bills that seek to address these issues. I hope this presents an opportunity for some students who have time and interest to observe in real time one of our campaigns. The hearing is at 10:30 in room A2 at the State House. So turning first to my tribute to clients. At the very heart of legal services work is the representation of individual clients. It remains one of our most challenging and yet inspirational endeavors. Much has been written about how one should approach client representation in a poverty law practice. Gary Bello, one of Legal Services' inspirational founders who I had the privilege of knowing, advised us to confront the inevitable power dynamic by forming an alliance with clients. Lucy White has written eloquently about the need to be attuned to the, quote, power and visions that clients can bring to a shared project for change. And former Dean David Hall has counseled us to recognize and honor the deeply spiritual aspect of the practice of law. In the crisis-driven and now significantly under-resourced context of a legal services practice, I can personally attest to the difficulties of reaching these ideals. My own less sophisticated frame is to get permission to hear and then to try to truly listen to a client's story. I have found that if I think that a client's case appears hopeless on its face in light of the constraints of legal standards, it may well be due to my failure of empathy and hence creativity, my failure to fully engage with my client, and my failure to be truly attentive to his or her whole story. To guard against these failures is a lifetime work in progress. But for those of you who have yet to experience it, I can tell you that there is nothing quite like the high of winning a case for a client. I often find myself taking on an individual case because I need that reaffirmation in the work that I do, which lately tends to be much more policy-centered. Our clients sustain us through their courage. There is no braver soul than a person having to survive with few resources while challenging inequities in programs that should be providing assistance. However, as much as client work may be personally sustaining, in light of the forces I enumerated before, it is simply not enough to secure change. A court win, even in a systemic case where we obtain declaratory or class relief, or a successful legislative campaign, is only as good as the power that resides behind the victory. That lesson was forcefully driven home to me in the 90s when we won a class action restoring general relief welfare benefits for needy older workers, only to see the legislature completely eliminate the program less than a year later, and it has never been restored since. We need real power for lasting change, to win the campaign, and then to address the critical aftermath, the actual implementation of the victory. Our alliance with clients needs to include a broader alliance, one that includes community-based worker centers, labor, and certainly where possible, government, to ensure that the victory becomes institutionalized. So with these thoughts in mind, I would like to turn to our campaign on behalf of our clients who work in temporary jobs and especially day laborers. Day laborers typically obtain work in one of two ways: through informal, often street corner sites, and through formal temporary agencies. Day laborers who use these street corner sites can be vulnerable to abuse by unscrupulous employers who attempt to incite a downward bidding war for wages among the workers gathered at the corner. The employer tells these workers little, if anything, about the job. But also, day laborers who solicit work through more formal temporary agencies are also subject to systemic violations. A typical day for our clients who solicit work through a temporary agency would be as follows. Line up outside the agency at 4:30 a.m., enter the agency at 5 a.m., be dispatched for a job at 7 a.m., arrive by agency transportation to the work site by 8 a.m., wait until 9 a.m., work until 4 p.m. or later, wait for the van to return, get back to the office by 6 p.m., get paperwork processed, and receive a day's pay, if they're lucky, by 7 p.m. As difficult as this description sounds, one of the additional perils of day labor is the lack of such typical days. Day laborers may easily wait for 4 or 5 hours, only to find out that there is no work that day after all. May be stranded at a job site if the agency van does not come to pick them up. May be forced to work 16 hours a day and they get no more work that week. May have to pay rent for equipment that is used on the job, or buy the equipment outright for a job that may last for only a few days, and may be injured on the job and have no idea about workers' compensation, or be pressured into not filing if they want more work. Confronting these issues on an individual client basis is extremely difficult. It is necessary to build trust, do outreach into the community, and overcome very well-founded fears of retaliation. For example, Labor Ready, operating as one of the largest temp agencies employing day laborers in the United States with storefronts in over 700 low-income communities, has a sophisticated computer tracking system. Once a name is inputted into their system as someone who complains, no matter how legitimate the complaint, the individual will never be hired again in any of their 700 locations. Because the employment arrangements are often informal, it is often extremely difficult, if not impossible, to obtain the kind of documentary evidence, like payroll records and employment applications, that either we or governmental agencies require in order to pursue their claims. Other barriers to traditional legal redress includes the fear of deportation, Many workers are homeless. The legal system is slow, and they do not have a phone and are transient. In addition, the violations are so pervasive that they are considered the norm by workers who don't realize that what they face repeatedly is against the law. Nonetheless, for many workers, because of what they see as their limited job prospects, and now more than ever, they are fearful of coming forward and jeopardizing in any way what may be their only source of income for themselves and their families. The difficulty of approaching these issues simply through individual client representation illustrates, I hope, why my talk is also a tribute to community-based organizations, and in this case, to immigrant worker centers. The rise of immigrant workers and the growing exploitation of these workers has led to the development of worker centers. These centers provide a variety of services, including recovering unpaid wages, English and citizenship classes, and worker rights clinics. And their numbers have been growing. By 2006, over 140 centers existed in 31 states, the majority of whom worked with immigrants, including several in Massachusetts. Working in collaboration with immigrant worker centers has been one of the most important developments in the work of the employment unit at GBLS. On a national level, the National Day Labor Organizing Network, or NDLON, works to improve the lives of day laborers in the United States in partnership with member organizations throughout the country. Although Massachusetts does not yet have an NDLON member organization, 2 immigrant worker centers, MASCOSH, standing for the Massachusetts Coalition on Safety and Health, and the Chelsea Collaborative have stepped into the void. MASCOSH brings together workers, unions, community groups, and health and safety activists to organize and advocate for safe, secure jobs. The Chelsea Collaborative is also impressive and has recently begun developing its worker center through a community leadership institute with participation by one of our lawyers. It is worker centers such as these that not only build the full trust and confidence of workers, but ensure that the workers have a voice in the struggles that affect their lives. Listen to a worker who spoke with MASCOSH in Chelsea. The man who hired me never mentioned how much I was going to earn. He told me to get into the van that was crowded with more than 10 people sitting on top of each other. I realized that there was no time to ask questions or make complaints. We arrived after an uncomfortable hour ride to an unknown place. In response to the woefully inadequate information provided to workers in temp jobs, working with MASCOSH and Chelsea Collaborative, we have reintroduced a bill, the Temporary Worker Right to Know Bill. Under current law, a temporary agency or day labor employer does not have to reveal to workers where they are going to be taken to work, the types of duties they will perform, how long they are going to work, and how much they will be paid. The bill would require these employers to provide workers with the most basic information about the job they are being hired for in the language in which the employer usually communicates with the worker. So at heart, it's fundamentally a right-to-know bill. A simple form is all that is required. And yet, this is the 3rd legislative session in which we are trying to get the bill passed. The difficulty of moving any legislative agenda for workplace rights leads to my tribute to labor. Our partnership with labor has become an integral part of our work at GBLS, where we are all members of the National Organization of Legal Services Workers, Local 2320 of the UAW. In 1979, 1 year after I started working at GBLS, we formed a union, and to get our first contract went on a 1-month strike that year during a very cold October. When we picketed downtown in front of our main office, I remember lawyers in the private bar coming up to us to tell us how our behavior was unbecoming to the profession. Yet when we picketed in front of our neighborhood storefront offices, which is what GBLS looked like before Reagan, Our clients marched in our picket lines, bought us coffee, and even, as I recall, warm gloves, and cheered us on. For me personally, that experience caused a sea change in how I related to my clients. We were one movement in solidarity against the man. Joe Messer, who was our union's inspiring organizer, furthered our education as union members by urging us that as poverty lawyers, we must realize our role included bridging the divide that sometimes existed between poor people and the labor movement. So as an employment lawyer, it was an easy step to act on Joe's advice and consciously work with labor, first on issues concerning the minimum wage and unemployment, and then on issues affecting welfare recipients, undocumented immigrants, poor working parents, and now day laborers. On a national level, in 2006, the National AFL-CIO passed a resolution allowing for affiliations of worker centers with state federations and central labor councils, and simultaneously entered into a national partnership with Endalon, the day labor organization. Through this significant alliance, the two organizations work together on immigration reform that supports workplace rights, and together against punitive anti-immigrant and anti-worker legislation. On a state level, for the first time this year, the Massachusetts AFL-CIO has included the Temp Worker Right to Know bill amongst its top 10 priority bills. And happily, the list of 10 also includes our paid sick days bill, as well as a bill that includes numerous unemployment reforms that would help our clients. The Massachusetts AFL-CIO president, CLC presidents, and other unions have come on board in full support of workers who are not in a union, but whose exploitation they not only deplore, but realize lowers wages and destroys working conditions for all workers. These labor leaders will be on hand tomorrow at 10:30 in room A2 to testify at the hearing. But you may be thinking that although this bill is a first step, in the scheme of things, it's surely a baby step that does not change the reality of often abusive working conditions of our clients. So what is needed and how do we get there? Several insightful articles have been written by George Jonas, who has studied the rise of the temp industry. In doing so, he has documented the differences in laws that govern labor unions and the temp industry. One obvious difference is that whereas unions negotiate on behalf of their members to secure decent wages, benefits, and grievance procedures, the staffing agencies seek to please their client, the user-employer, and keep costs down for the employer, maximize their own profits through low wages, no benefits, and no avenues of redress for abuse. Another significant difference is that whereas unions are highly regulated under federal law, temp agencies were excluded from any federal oversight legislation, and yet have managed to also exclude themselves from any state regulatory scheme as well. Bear with me for a moment as I describe how this happened. Employment agencies, those who charge workers a fee for placement into a job, such as modeling companies, became highly regulated in the 1930s to address their practices as employment sharks for charging high fees. Most states had laws regulating agencies, and until the 1960s, temporary help agencies were classified under these laws as employment agencies. Then, in what amounted to an under-the-radar screen stealth operation, the staffing industry in the 60s and into the early 70s persuaded business-dominated legislatures to exempt staffing agencies from oversight under the employment agency laws, leaving them totally unregulated. They argued that they were not employment agencies, but the workers' employers, because they handled the workers' pay and assignments. This exemption from the statute meant that the temp industry no longer had to keep records of placements, wages paid, fees charged, nor were fees for equipment, check cashing, and transportation constrained in any way. Additionally, through their newly won employer status, their user-client firms were freed of many legal obligations. The year of the greatest growth in temp agencies, 1973, is not coincidentally the same year that economists have called the, quote, great U-turn that marked the beginning of the downward spiral of workers' income. Like the financial market fiasco, this too is an example of how the absence of regulation leads directly to exploitation, undermines basic workplace rules of fairness, reduces income, and contributes to growing wage inequality. And here is where my series of tributes today comes full circle back to Northeastern Law School. The agency that has the potential to have regulatory oversight of temp agencies is the Massachusetts Division of Occupational Safety, a division under the Executive Office of Labor, a secretariat newly restored by the Patrick administration. Its commissioner is a former Northeastern co-op student of mine, and of course, an alum. As a progressive, enlightened, quote, bureaucrat, in the fondest sense of that term, this commissioner has reached out to immigrant worker centers and labor. We have worked together on a bill, an act relative to the regulation of employment agencies, which will also be heard tomorrow at 10:30 in room A2. This bill will put temporary agencies back into the statute that now only regulates employment agencies. The bill includes full disclosures that are present in our temp worker right to know bill, requires licensing of both employment agencies and temp agencies, regulates fees, provides workers with protection against retaliation, and is enforced by the division and the Attorney General's office. The challenges in securing passage of this legislation are enormous. There are provisions of the bill which will appeal to business-friendly legislators. It streamlines the regulatory process. It levels the playing field for agencies that do not exploit their workers. It brings new fees to state coffers. Nonetheless, it will be forcefully opposed by representatives of the temp industry's national umbrella organization, an organization that is extremely well-funded, has a sizable presence and political clout in most state legislatures, including Massachusetts, and we are challenging its very reason for existence, to keep the industry free of any regulatory oversight. And even were this bill to pass, the legislation alone is not enough. It will require community vigilance, significant organizing, strategic legal advocacy, and so much more. But what we bring to the table to confront these challenges is what today's tributes are all about. It is a tribute to our clients whose lives give voice to moral imperatives, to the immigrant worker centers who earn and inspire workers' confidence and point the way to collective solutions, to a labor movement that reaches out to speak for all workers, even those who others seek to marginalize, to my incredible colleagues at GBLS, including our executive director, Bob Sable, and always to this law school. For as the former dean, David Hall, said in his final commencement speech, and I quote, "Those of us who have come to Northeastern Law School never leave because it imbues us with values, skills, and memories that empower us for a lifetime." Thank you so much.
You can obviously see why. So now we have a bit of time for questions for Monica that I was going to field. But the first question I want to ask you, Monica,
Um, well, I do really feel that I have the best law job in the city of Boston. It's true. But it really is all of the reasons that I enumerated in my talk, and not the least of which is the incredible people I work with. And some of them are here today: Tom Smith, Audrey Richardson, and Brian Flynn. We really have, we're an all-union unit at GBLS, and we operate as much as possible as a collective. And it's a team effort. And as I said, our clients and the worker centers and labor have been incredible partners. So I'm very lucky. Yes. Oh, sorry. You're supposed to be doing that.
Yeah, you. Oh, I don't know your name.
So I'm supposed to repeat the question because I have the little mic thing on my lapel. And the question was, how do we, in light of the importance of imaging, how do we convey the stories of our clients to legislators? And that's a really good question, and it has become increasingly a very complicated issue. Many of the problems that our clients confront, the people that experience the problems the most are often undocumented immigrants. And there is a strong anti-immigrant sentiment throughout the country and in state legislators. So we're always facing that difficult problem of, on the one hand, showing how totally exploited our clients are because of their lack of immigration status. And yet, on the other hand, we have to be careful to universalize the problems and make sure that legislators can relate to whatever problem it is we're bringing to them. The paid sick days is an example of that. No legislator ever goes without a paid sick day. They have total flexibility in terms of what they do. And so to bring these lessons home is very, very difficult. They just assume that it's not a problem. So imaging is very important. On the paid sick days campaign, one thing we're trying to do is to partner with other states to create a national buzz and to get more visibility for an issue, to bring it up through all of the noise so that people realize how pervasive this problem is and how it impacts us in so many ways, including now public health. And so we're very lucky to have the Obama administration that is going to partner with us on these efforts. And we just learned, for example, that Michelle Obama will be putting out a video that we're going to be able to use in the various states on the importance of family leave and paid sick days issues. So it's a great question. I don't think we've become nearly sophisticated enough on doing that, so I welcome you in our unit on a co-op to help us out. So the question, to repeat for my lapel, is given a description of the work that includes many forums, legislative, administrative advocacy, individual client work, working with workers' centers, working with organized labor, what can law schools do to bring that kind of approach more to bear in the classroom? Well, one thing I always tell students, and I've told them here while I've been here, is to take the Poverty Law Clinic, which I think is a great experience. And Professor Flynn, can you help me out here? I mean, one thing, just thinking off the top of my head here, the Northeastern alum who I talked about as my student, she actually worked at the Massachusetts AFL-CIO, but I supervised her so that she could have a lawyer supervising her. And there might be a way of doing that more in a variety of ways and in a variety of settings. It's difficult. But to have people stationed in different types of work. And I don't know if the co-ops also include co-ops at the State House, whether that has ever been done. It has, so that's good. But I would welcome other people's ideas on that. I think it's a great comment. Yes? So that's a great question. The question was housing. Do you want to rephrase it? Like housing where it might have been influenced by wealthier tenants influencing the housing system. Now that unemployment is becoming increasingly pervasive, can that have a positive impact on the rights of all workers in the unemployment system? That's a very interesting question. We're certainly seeing more and more workers who would never have walked into a legal services office a few years ago. That's absolutely true. And they're really shocked at how they're treated. You know, many of our clients and us as well, we kind of get beaten down collectively by the system and expect the kind of indignities that happen. And now when you have people coming who have never had to use any kind of help whatsoever, seeing firsthand how abusive the system is, how you have to wait forever, how you're accused of fraud for no good reason, et cetera, et cetera. I think that is something that we will hopefully be able to tap into. Some states have coalitions of unemployed workers, and we're now at the beginning stages of working with a group to form a council of unemployed workers. And it really needs, I mean, we bring, you know, our lawsuits, we go to the State House, but it needs a group of angry, affected people to start to move the system in a more humane way.
I have two questions.
Uh-oh. Going to regret that question. Yes, okay. So 2 questions. One is, what is it about your early life that led to your passion? And second, as a woman with a family, how can one lead one's life as a lawyer and have another life? So the first question. So I did have an amazing family and an amazingly courageous mother. My background, and I'll try and be very quick, so kick me, is my parents are from a small town in Czechoslovakia called Nitra. And my father was a lawyer, and this is in the 30s, and starts to notice the rise of Nazism. And finds an ad from a British couple willing to pay passage out to Hawthorne, outside of London, for a married couple to be a butler and maid. So my dad proposed to my mom, and they tried to convince other families to leave. And out they went in 1938, right through Germany, to be outside of London as a butler and maid. And my mother, good Eastern European, knew many languages and ended up working in London decoding German messages. And soon learned that all the Jews in Nitra had been rounded up and taken to Auschwitz. And my father was in the army, and after the war ended, they decided they had to go back to see if anybody was still alive. And they returned to Prague, and the border sealed, and they were not members of the Communist Party there. And so they were told that they would have to leave Prague and live in literally a mud hut. And my mother was the one who said, this is not how I'm going to raise my daughter. And there were guides taking people out across the border. So they went on a very cold night because if you were caught, you were shot on sight. And my father carried me on his back in a sack, and as I've told some students, they drugged me so that I wouldn't talk, but I never stopped talking. So, and managed to escape, and we ended up in Toronto. And my mother, in later years, would always poo-poo that, and I would always tell her what a brave person she was and how I would never have had the courage to do that. The other thing they did was they hid the fact from me that I was Jewish. And I didn't find that out until I was 16 at a cousin's wedding in a temple with all my relatives wearing yarmulkes. And so I learned from that was always a deep, dark, shameful secret. So I think that helped me, all those experiences helped me empathize with our clients who, just like the Jews in Europe, are marginalized. First it was welfare recipients who were considered the evildoers, the cause for all problems in this country. And more recently, it's immigrant workers. And so I think that background is what contributed to my desire to work in the area that I do. In terms of the second question, my colleagues are laughing because I have no life. I work all the time. I have an exceedingly patient husband. My kids are now grown, and I don't have a good answer.
But you're always saying that they don't have a life, too.
Yeah.
You're always saying that Brian shouldn't work so hard.
That's true. That's true.
But you did manage to have your kids raise them in the context.
Right.
And
Right.
they're wonderful kids.
They are wonderful kids.
Other questions, Rachel?
Well, one of the things that really is so extraordinary about the Columbia unit, apart from a lot of other places, well, there's 2 things. One, the fact that all that you represent people regardless of race. Words of how that's possible. And secondly, the involvement with the community. And it's just a special aspect of your work. I was hoping you could talk how those relationships are built, how you decide which
So, two-part question. One is, how did it come about that GBLS represents immigrants and undocumented workers? And then second, how does that work progress with the various worker centers, and do we meet with members or leadership, et cetera? So the first answer is really a tribute to our executive director, Bob Sable. In the 1990s, well, to step back a minute, legal services was traditionally federally funded. It started as a program of the Office of Economic Opportunity, part of the War Against Poverty, and there was a legal services corporation established that funded programs all over the country. And that federal money was always restricted, but you could do whatever you wanted with the state funds and with grants, etc. When Newt Gingrich came along in the 90s and had the contract on America, one significant change he did was to change the Legal Service Corporation rules that not only your federal funding would restrict what you could do, but all sources of funding would be restricted. So what that meant was that we could no longer represent immigrants, not participate in welfare reform, not do class actions, not do legislative advocacy, not do any cases that resulted in attorney's fees. In other words, not to do anything effective on behalf of poor people. All you could do was represent individual clients. And it's really through the leadership of Bob Sable, our executive director, that we decided to give up $2 million of federal funding in order to continue to be true to our mission. And so that's how that came about. We were fortunate that we have great fundraisers in our program. We rely now on state funding and grants, but it was a significant sacrifice, but really, really well worth it, and enabled us to continue that work. Some programs around the country did that as well, but others just couldn't afford to do that, and so they remain to this day under these restrictions, but we're really hopeful that with this Congress and this president that we'll finally get rid of those barriers to representation. Your second question about, and your comment about working with worker centers. So this is not a tribute to me at all. This comes from other folks in my employment unit. They've really led the charge. Audrey has been really the leader of this effort, and we have other folks in our unit, and Tom Smith, who's a SCADN, who came to work on worker centers issues, are really the inspirational forces behind doing this. And as you can imagine, any work with community groups, especially now where everybody is under-resourced, where everybody has such high demands placed on them, is very complicated and very difficult. There are turf wars, there are differences in philosophical opinions, so it's a difficult dance, and but still really worthwhile. And what Audrey does is work with this collaborative that I mentioned. So there's both overarching work where all of the groups can come together and forge some joint strategies. And then we also work with the individual worker centers on what matters to their members. And Tom has reached out to the Metro West Worker Center, and really works there with the members as part of the center on his off time in the evenings, in addition to doing his other legal work. So it too is a work in progress, but it's really, really worthwhile, and this is a relatively new phenomena in our work, but a really great direction that we're going in. Yes?
When you're hearing or feeling, how do you restrain the voice in your head that says, that wants to call certain things what they are, that wants to call bigotry bigotry? It's completely unhelpful, but sometimes that is what it is. And how do you control that
So the question is, how do you confront bigotry and yet control your reaction to what you are hearing? Not said as eloquently as you did, I apologize, but a really good question. So it's really hard. It's really hard at the State House. In fact, a wonderful colleague of mine, because now I'm theoretically the legislative lead, came to me to confess that she lost it at a legislative hearing. I was supposed to give her, say it's okay. So, and she's a seasoned attorney, so it's very difficult. It's easier to what is lawyering all about anyway? It's learning a set of rules, right? Those of us who don't like conflict like being lawyers because the rules are designated. The plaintiff stands here, the defendant stands there. The legislator sits there, you stand there. So it kind of constrains, it's a set of principles constraining your natural impulses. And then the other constraint is that you're doing something on behalf of a client. That makes it so different. The old adage that you can never be your own attorney, it's because you'll totally blow your own case, because you'll yell out, etc. But when you're doing it for somebody else, when the stakes are so high for somebody else, that's what helps, put the muzzle on.
I'm just curious, you guys are working a lot of issues right now. Are there any issues in the future that you want to tackle as an unemployment?
So the question is, we've tackled a lot of issues, and are there any other issues that we would like to tackle? Well, I always play the lottery for one reason, and one reason only, is I want to hire up hundreds of people to be in our employment law unit. We are just scratching the surface. There are so many things we should be doing that we don't do. We used to, many, many years ago when we were better resourced, way back in the President Carter days, we used to do employment discrimination cases. The need for that has not gone away, and yet those cases are so resource intensive that we don't do them. Sexual harassment in the immigrant community is huge, a huge problem. So, there's more than enough issues that could keep us busy, and it's really hard. It's very difficult. I was just talking to a student who I met with today, and we were talking. She asked me how you decide what cases to take and what not, etc. And I can tell you that even after 30 years, saying no is the worst thing we have to do. We're the only game in town for a lot of people, and there's too many people we have to say no to. So come work in our unit on co-op. So the question is, do we have any partnerships with the local Boston firms? And the answer to that, happily, is yes. All of the major downtown law firms partner with us in various ways. They have sometimes co-counseled cases with us. If we're negotiating a settlement and we have no clue about the tax consequences, we can call up the tax department of a big law firm. Many of them have been very generous with their time. In addition, in the summer, we have a special project with 5 of the law firms, and that is to increase the amount of representation we can provide in unemployment insurance cases. Our case inflow is actually constrained by our intake system because so many people are calling our lines that there's up to a 45-minute queue sometimes for people to get through. And if they did get through, we wouldn't be able to represent them. So in the summer, we put on an extra line right on our floor, and the cases come pouring in, and we train the law student interns at 5 major downtown law firms. So we train up about 200 students, and refer the cases to them. We first go train them and refer. So there's a number of partnerships. That's just the one in my unit, but there are partnerships like that with all the units at GBLS. Thank you, Lucy. Thank you.